हॅलो, आज असाइनमेंट सबमिट करायची शेवटची तारीख होती. काय स्टेटस आहे अवधूत ठोंबरे? हॅलो,
हा सबमिट केली सर असाइनमेंट.
सबमिट केली ना?
हो केली, काल केली सर.
ओके ओके ओके.
ओके.
ज्योती दिंडे, क्षितिजा डोंगळे, नमिता सावंत. कोणाचं राहिलंय असं काय का कोण करू शकत नाही किंवा काय आता उपस्थितांपैकी?
सर असाइनमेंट रेडी आहेत, फक्त उद्या सबमिट करणार आहे मी.
कुठलं स्टडी सेंटर?
SGM कॉलेज, सद्गुरू
चालेल.
काटके महाराज.
चालेल, करून टाका, काय प्रॉब्लेम.
Sir, I already submitted.
ओके, नो प्रॉब्लेम.
सर आम्ही पुण्याला असल्यामुळे 1-2 दिवसात सबमिट केलं तर चालेल का?
कोणता स्टडी सेंटर?
पलूस.
चालेल चालेल, काय प्रॉब्लेम.
चालेल ना? ओके.
येस येस.
सर, इचलकरंजीच्या स्टडी सेंटरला त्यांनी म्हणतात की हॉल तिकीट आल्याशिवाय सबमिट करू नका, कारण की त्याच्यावर सीट नंबर आहे बोलले ते.
ठीक आहे, केसरकर सरांची झाली चर्चा. ते म्हणतात सीट नंबर झाल्याशिवाय आम्ही जमा करून घेणार नाही. हरकत नाही, इचलकरंजीला तसं करा.
ओके.
ओके.
गुड मॉर्निंग सर. सध्या मी पुण्यात आहे, तर 2-3 दिवसात सबमिट करीन मी असाइनमेंट्स.
चालेल चालेल, नो प्रॉब्लेम, काही प्रॉब्लेम.
ओके सर, थँक्यू.
आणि कोणाला शंका असतील तर बोला. 5 मिनिटं आहेत सर जॉईन होईपर्यंत. बरोबर सर, बरोबर. ते एकच आहे ना?
हो.
बोला.
सर, असाइनमेंट सबमिट केल्यानंतर आपल्याला ग्रुपवरती किंवा तुम्हाला इन्फॉर्म करावं लागेल काय सर?
काय आवश्यकता नाही.
ओके.
हा, कुठले म्हणे सर? 5 मिनिटात सेशन चालू होते आपण 5 मिनिटं.
हॅलो डिअर स्टुडंट्स, आवाज येतोय? अभिजित पाटील.
येतोय सर, आवाज येतोय.
Good morning. Sorry for delay the session because of the network issue. We'll start now. PPT दिसते ना सर्वांना?
हो सर.
Okay. So in the last lecture we finished unit number 1 in which we will discussed about Indian Contract Act and the Sales of Goods Act. In the unit number 2, we discuss about the Negotiable Instrument Act 1881 and the Consumer Protection Act that is amended from 1986 to 2019. So first of all, we discuss on the Negotiable Instrument Act 1881, in which we focus on the characteristics of negotiable instrument. Then second one is a promissory note, bills of exchange and check. Then the Negotiable Instrument Act, in which section 46 to 60 we discussed here. Then special rules of evidence, in which the section 118 to 122 we discussed here. Then last one is a crossing of check and a dishonor of check, in which the section 138 to 142 we discussed in the Negotiable Instrument Act 1881. So first of all, we discuss on characteristics of negotiable instrument. First of all, introduction. The Negotiable Instrument Act was promulgated in the year 1881, which was introduced to simplicity in the growth of banking and commercial transaction. Basically, friends, the Negotiable Instrument Act is related and regarding to the banking sector. So that is simplicity in the growth and banking and the commercial transactions is important in this respect. The basic purpose was to authorize the system of negotiable instrument. The act was enforced during the British rule, and to date, most of the provisions still remain unchanged. Whatever the rule is given by the Britishers, that is not changed till date. So the Negotiable Instrument Act is followed by the government of India as it is from the British rule. So what is the definition from the Act? Section 13 subsection 1 of the Negotiable Instrument Act 1881 defines Negotiable Instrument Act as a negotiable instrument means a promissory note, bills of exchange, or check payable either to order or to bearer. So the section 13 subsection 2 also defines a negotiable instrument may be made payable to or more pays jointly, or it may be made payable in the alternative to one of two or one or some of the several pays. So basically काय आहे की या ठिकाणी निगोशिएबल इन्स्ट्रुमेंट काय केले जाते, ही एक प्रॉमिसरी नोट आहे. तर ते प्रॉमिसरी नोट काय केली जाते, ती ऑफर केली जाते आणि एक दुसऱ्या व्यक्तीकडून ती काय केली जाते, ॲक्सेप्ट केली जाते. नंतर व्हॉट इज इट मीन? A negotiable instrument refers to a signed document that contains a promise by a person being the payer to pay certain amount of money to the specified person or the assignee being paid either on demand or at a specified date in the future. The instrument is said to be negotiable since it can be freely transferred by one person to another, and the transferee of the instrument gets a clear title of the said instrument. Basically, what it means that the one person promissory notes offer to another person with the specific date and with the specific amount. So negotiable instruments are a vital to the economy and as recognized globally as medium of a payment. They can freely transferred from one person to another, which makes them more useful, and parties can use the meet their payment obligations. However, due care shall be taken when writing a negotiable instrument, especially when the same is made payable to a bearer as a person acquiring the same by unfair means can try to misuse the instrument, and legal actions can take some time thereafter. So basically meaning हेच आहे की एक व्यक्ती दुसऱ्या व्यक्तीला काय केली जाते या ठिकाणी प्रॉमिसरी नोट ही ऑफर केली जाते. Then what are the characteristics of negotiable instruments act is first one is a property. The possessor of the negotiable instrument act is acknowledged to be the owner of a property contained therein. So negotiable instrument does not simply give ownership of the instrument but right to property as well. The property in the negotiable instrument can be moved without any formality. In case of the bearer instrument, the possessions passes by the merger delivery to the transferee. In case of a order instrument, endorsement and delivery are necessary for transfer of property. Then second one is title. The transferee of negotiable instrument is called as a holder in due course. A genuine transferee for value is not affected by any flaw of title on the part of the transferor or of any of the previous holders of a instrument. So the third one is a rights. The transferee of the negotiable instrument can take legal action on his name in case of a dishonor. A negotiable instrument can be reassigned any number of times till it is attains maturity. So the holder of instrument need not give notice of transfer to the party legally responsible on the instrument pay. So the fourth one is a characteristic is a presumption. The certain presumptions are applicable to all the negotiable instruments. That is a presumption that deliberation has been paid under it. It is not essential to write a promissory note the words for value received or alike expressions for the reason that the payment of consideration is acknowledged. That is the presumption characteristics which is given in the act. Then fifth number is a prompt payment. A negotiable instrument facilitates the holder who anticipate prompt payment because dishonor refers to the renew of credit of all persons who are parties to the instruments. So this is one of the characteristics or features of the negotiable instruments. Then the transferable, these instruments can be easily transferred by the holder to the another person, either by delivery or by making a lawful endorsement. If the payee is not mentioned in the instrument, then the transfer can be made by mere delivery. And if the payee is mentioned, then the transfer has to be made by endorsement in the name of the another person or assignee or bearer. So this is also transferable is one of the important characteristics of a negotiable instrument act. Then seventh is a right to receive payment. If the negotiable instrument is not honored on the specified date and the holder of the instrument doesn't get the payment, then the holders becomes entitled to take legal action against the payer. This applies even if the instrument was not initially issued to the holder but instead transferred. So this is one of the right of receive the payment from the payer is important in the respect of characteristics of negotiable instruments. Then last one is a title of transferee. The transferee of the negotiable instrument gets a clear title of the instrument and is known as the holder in due course. This means the title of such a transferee who acquired the instrument by legal means shall not be affected due to the flaw or illegality in the title on account of the transferor or any other previous holders. These are the some basic characteristics given in the act. So next is a we want to understand what are the types of negotiable instruments. First one is a promissory note, second one is a bills of exchange, third is a checks, and fourth is a demand drafts, that etc. So first is a promissory note. So what is promissory note? A promissory note is an instrument in writing, not being a bank note or a currency note, contained an unconditional undertaking signed by the maker to pay a certain sum of the money only to or to the order of a certain person or to a bearer of the instrument. So that is the simple definition given of the promissory note. Then what is bills exchange? A bills of exchange is an instrument in writing contained an unconditional order signed by the maker directing a certain person to pay a certain sum of money only to or to the order of a certain person or to the bearer of the instrument. So that is the basic definition given. Then what is check? A check is a bill of exchange drawn on a specified banker and not expressed to be payable otherwise than on demand, and it includes the electronic image of a truncated uh, check and a check in the electronic form. So this is also a check definition. Then drawer and drawee, the maker of a bills of exchange or check is called as the drawer, and the check the person thereby directed to pay a called the drawee. The next is promissory note. So these are the instruments that are signed by the payer and contain a promise to pay a certain amount of money to another person or his or her order or to the bearer of the instrument at a certain date. The promise to pay shall be unconditional, following which the note shall not be called as promissory note. The person making the note is known as the maker, and the person to whom such a note is being made is called as payee. For example, Amar makes a promissory note in writing to Baban stating that I shall pay rupees 10,000 to Baban on 15th February 2023 and signed the them. So this is one of the example of the promissory note where the Amar make the promise to the Baban for paying 10,000 rupees on the date. So that is one of the example of the promissory note. So what are the types of promissory notes? First type is a personal promissory notes. Second one is a commercial third one is a real estate, and fourth one is a investment. So what is personal promissory note? This is a particular loan taken from the family or friends. Though people avoid legal writings when seeking a loan from close contact, the promissory note shows belief and trust in the interest of the borrower. So अशा पद्धतीचं काय आहे, पर्सनल प्रॉमिसरी नोट सुद्धा काय केले जाते, फ्रेंड्स किंवा फॅमिली मेंबर्सकडून तयार करून घेतले जात असते. तर ही पर्सनल प्रॉमिसरी नोट म्हणून बघितले जाते. देन कमर्शियल, द नोट इज मेड व्हेन डीलिंग विथ द कमर्शियल लेंडर्स सच ॲज अ बँक्स. Most of the commercial promissory assign agreements is similar for the personal notes, which is made by the bankers. Then real estate, this is similar to the commercial notes in the terms of non-payment consequences. If the borrower become a defaulter, then the party has the right to keep the property until the debt is cleared. It is a little risky as all the essential details become public, which can hinder the borrower's credit history in the future. So real estate is one of the type of promissory note which is similar to the commercial promissory notes. Then the investment, the promissory note is occasionally used to raise the funds for the businesses. The company raising the funds with the help of investment and using the promissory notes in the raising funds. It is used as a security purpose and managed by the securities law. It includes terms and conditions related to the whatever the returns given by the businesses or the companies to the shareholders or the stockholders. So what is next? Parties, which are the parties involved in the promissory notes? All promissory notes constitute three primary parties involved while making the promissory notes. These includes are drawee, drawer, and payee. So what is drawer? A drawer is a person who agrees to pay the drawee a certain amount of money on the maturity of the promissory note. So he or she is also known as a maker. So drawer is also called as a maker of the promissory note. So what is next? Drawee. She or he is an individual in whose favor of the note is prepared. In usually case, the drawee is also the payee until and unless the promissory note is not is transferred, especially in the favor of the payee. For example, Ram is considered a drawer if he promises to the pay to the Sham rupees 5,000. So Sham is here drawee. However, if the same promissory note is transferred in the favor of Rohan, the Rohan becomes a payee. So a payee is someone to whom the payment is made. So these are the parties are involved whenever the promissory note is made by the parties. So the next, the features of the promissory note. The first one is a printed or written agreement. Then second one is a pay defined amount. Then third one, signed documents. Fourth one is a unconditional promise. Then fifth one is a legal composition. Sixth one is a detailed information. So one by one we discuss here. Printed or written agreement. A promissory should be in written, and an oral promise to be pay money is not accepted. So whenever the promissory note is written, the evidence is proper. So the next one is a pay defined amount. It is a promise to pay the money on a particular time or when demanded. So the mentioned amount can neither be added or subtracted. So the pay defined amount should be given in the promissory note. It is a mandatory to both the parties. So third one is a signed documents. The document is duly signed and drawn by the drawer and stamped. So whatever the document, what is the promissory note is there, that should be signed by the both the parties and it should be the stamped by the authorized person. So fourth one is a unconditional promise. The promise to pay a certain amount of money must be absolute in all cases. In such notes, a conditional guarantee is not accepted. So unconditional promises is not there in the promissory note. Then fifth one is a legal composition. All the payment should be made in the nation's legal currency. So when you are going to be make the promissory note in the nation, the currency should be followed whatever the nations given in the legal format. So these are the five features of the promissory note, and the last one is a detailed information. The note has all the required information including the name of the drawer and payee, date of the maturity, then the terms of the prepayment, issue date, name of the drawee, name and the signature of the drawer, principal amount and the rate of the interest. These are the contents or elements. It should be the given detailed in the promissory note, so that the promissory note will be the finalized by the both the parties. So next one is a bills of exchange. So what is the bills of exchange? Bill of exchange contain a direction and order made by the maker of the instrument instructing a certain person to pay specified amount of money to another person, or his or her order, or to the bearer of the instrument at a specified date. The person making the instrument is known as a drawer, and the person on whom such an instrument is drawn is known as a drawee or the acceptor. The payee may or may not be the drawer. So we want to understand what is the definition of the bills of exchange. According to section 5 of the Negotiable Instrument Act 1881, the bills of exchange is an instrument in return writing contained an unconditional order signed by the maker directing a certain person to pay a certain sum of the money only to the order of the certain person or to the bearer of the instrument. When this order is accepted, writing, it becomes a valid bill of exchange. So there are different types of bills of exchange which we will discuss here. Before that, we are going to discuss here what are the parties involved in the bills of exchange. A bills of exchange has the following parties. That is, first one is a drawer. Drawer is the person who makes or writes the bills of exchange. Normally, he is the seller. So second one is a drawee. Drawee is the person on whom the bills of exchange is drawn for his acceptance. Normally, he is the buyer. So drawer is the seller and drawee is the buyer. He has to pay the amount of the bills of exchange to the drawer on the due date. Whatever the due date given on the promissory note or the bills of exchange, the given by the drawer. So the payee is one of the person to whom the amount of the bills of exchange is to be paid. The payee can be the drawer himself or the creditor of the drawer. Now, the endorser is the person who transfers the whatever the rights of the payments. That is his endorser. So endorsee is the person in whose favor the bills of exchange is endorsed by the drawer. Then bearer is the person in possession of the bearer bills of exchange. So these are the parties involved in the respect of bills of exchange. Then types of bills of exchange. First one is a trade bill and second one is a accommodation bill. Bills of exchange facilitate trade transactions involving sale or purchase of goods, but this mechanism of the bills of exchange can be also used in the raising of the funds or the finances. Type of bills of exchange depends on its object or their purposes. From the accounting point of view, bills of exchange having two types. That is, one is a trade bill, where the bill of exchange is drawn and accepted to settle a trade transaction. It is called as a trade bill. So this bill of exchange is drawn by the seller of the goods and it is accepted by the buyer. So it is a trade bill. Then what is accommodation bill? Where a bill of exchange is drawn and accepted for mutual help. It is called as a accommodation bill. This bill is for mutual benefit without a trade of transaction. It does not involve a sale or purchase of any goods or services. This bill carries an agreement between the two parties for the purpose of giving financial support to each others. So that kind of a accommodation bill is there. So these are the two major types of the bills of exchange given in the Negotiable Instrument Act. So what is the difference between the bills of exchange and promissory notes? We want to understand by the number of points is there. So first is a definition that we will discuss here. So negotiable instrument issued or order the debtor to pay the creditors a certain sum of the money within a specific date or a specific period of time on their demand. So the what is promissory note? A negotiable instrument issued by the debtor with a written promise to pay the creditor a certain amount within a specific date or specific period on the demand. And the definition given under the section of 5 of Negotiable Instrument Act 1881, that is bills of exchange, and under the section 4 of Negotiable Instrument Act 1881, the definition given of for the promissory note. Then who is issued the bills of exchange? The creditor issued the bills of exchange and the debtors are issued the promissory note. So what are the parties involved in the respect of bills of exchange? Three parties involved, that is drawer, the drawee and a payee. These are the three parties involved in respect of bills of exchange. And in respect of the promissory note, there are two parties involved. First one is a drawer that we can call a maker, and the second one is the payee. Then the acceptance, drawee needs to accept हॅलो, आवाज येतोय ना? हॅलो,
हा सर येतोय.
येतोय ना? जस्ट Okay, so who will accept the bills of exchange? So drawee needs to accept the bills of exchange before the payment made by the secondary party. Then in respect of promissory note, no acceptance required from the drawee. So next one is a liability. Liability of drawer is secondary and it is conditionally liability. In respect of promissory note, liability of a drawer is primary and it is absolute liability in respect of a drawing. Then next one is a dishonor of instrument. Notice served to all the concerned parties involved in the transactions on dishonored of the instrument. So whatever the parties involved, that is given in the third, fourth number point, that parties involved drawer, drawee and payee, that all the concerned parties involved in the transactions on dishonored of the instrument. So in case of a promissory note, no notice served to the drawer in case of a dishonor of the instrument allotted by the parties. So in case of copies, bills of exchange can have the copies, but in case of promissory note, it allows no copies given to the any parties. So these are the difference given in the act. So next one is a check. So check are the bills of exchange that are drawn by the person making such a checks on the specific bank, instructing the bank to pay a certain amount of the uh, money to a person mentioned therein on their demand. So the person signing the check and making the instructions to the bank is known as the drawer, and the bank becomes the drawee, and the person to whom payment is to be made is known as the payee. So the three parties is here, that the bank is a drawer, then the instructions given by the person, that is the drawer, then the bank is the drawee, and the person whom the payment is made, that person is the payee. So in respect of these three parties is important for the given the check. So what is the meaning? Checks are also called as a negotiable instrument. In the banking terms, a negotiable instrument is a document that promises its bearer uh, a payment of a specified amount either on furnishing the document to the banker or by the given date. A check is a piece of a document or a paper which orders the bank to transfer money from the bank account of an individual or an organization to the another bank. So it is a meaning given in the act. So essential ingredients are there. There are certain points to remember regarding the checks which are given here. First one is a check can only be issued against a current or saving account, bank account. Then second one is a check without date shall be considered as a invalid check. So the check should have a proper date given in the written format. Then third one is only the payee in whose name the check has been issued can encash it by the person. Then a check is only valid for the 3 months from the date of it has been issued by the persons. Then A9 digit MICR, that is a magnetic ink character recognition code mentioned at the bottom of the check, that is the major essential ingredient given by the banks. This make the clearance of the check easier for the bank. So these are the essential ingredients given in the Negotiable Instrument Act in respect of the check. Then types of the checks, there are 9 types here given under the act. First one is bearer check, then the order check, Then third one is a crossed check. Fourth one is a open check. Fifth one is a post-dated check. Then stellar check, traveler check, then self-check and banker check. So the checks is known for all of you. So we are not here discussing about the types of the check. So what are the requirements for the negotiable instrument? So the first one is a certainty in time of a payment, then uh, definite amount, then unconditional payment, a written instrument, then signed by the maker, payable in money. So the requirements is given. The time at first one is a certainty in time of payment. The time on at which the payment will be made by the payer shall be certain and determinable, even if it is not in any specific date. It should be mentioned either a specific date or the determinable event upon which the payment shall be made. Like the payee can mention that the amount will be paid on some date or after some months or after the date of the some of the person on the demand and so on. So certainty in the time of payment is required whenever the negotiable instruments made by the parties. Then the second one is a definite amount. The amount to be paid shall be clearly mentioned without any ambiguity, or the any instrument without any definite amount shall be invalid. So definite amount should be given in the that note. Unconditional payment, the promisee or the promise or instructions to be pay shall be unconditional, and the payment shall not be subjected to any condition or upon the occurrence or non-occurrence of any certain or uncertainty given in the events. So written instrument, the instrument has to be in writing, and the oral instrument have no legality or the validity for the notes. So signed by the maker, the person making such a negotiable instrument shall be signed for the same anywhere on the instrument, and appoint an authority or authorized representative to sign the same. So sign is important in respect of the negotiable instrument, and it is necessary or required for the making instrument. So the payable of money, the mode of the payment shall be money only, and non-monetary payment shall not be from the part of the negotiable instrument, such as a payment cannot be made in the format of the bonds or shares or gold coins and so on. So the payable in money is required in the respect of negotiable instrument note. So the next is a negotiation. So what is negotiation? In the chapter 4th of the Act provides for the process of negotiation. In section 14 defines what is negotiation. A promissory note, bills of exchange or a check is transferred to any person so as to constitute that person the holder thereof. The instrument is said to be negotiated. Some of the sections are given here in the Act, that is section 46 of the Negotiable Instrument Act is related to the delivery. In the section 47 of the Negotiable Instrument Act, it's related to the negotiation by the delivery. Then the negotiation by endorsement is related to the section 48 of the Negotiable Instrument Act 1881. So these are the act also given in the then special rules of evidence from the section 1182 to 122 of Evidence Act 1872 is comes under the Negotiable Instrument Act 1881. So what is in case of special rules of evidence, first given in the presumption. What is presumption? A presumption is a rule of a law that is used by the courts or the juries from the where they obtain a particular inferences from the particular fact or the evidences, or unless and until the truth of the such an inferences is disproved. So this presumption is also important under the special rules of the evidence for the Negotiable Instrument Act. It is only an inferences as to the existence of one fact from the existence of some other fact founded upon the previous experiences of their connections. There are three classes of the presumptions in the Special Rules of Evidence Act in 1872: presumptions of the law, presumption of the fact, and a mixed presumptions of the fact and law. So this is the given. Here is the presumptions of law definition given: a rule of the law that a particular inference shall be drawn by the court or jury from the particular circumstances, and the presumptions may also be rebuttal, then irrefutable. It is to be noted that the question of presumption must be placed in distinction with the questions of the group. Then the crossing of check and dishonor of check, section 138 and to 142 of the Negotiable Instrument Act 1881, section 138 of the Negotiable Instrument Act 1881 of Negotiable Instrument Act states that the dishonor of the check for reasons stated, insufficiency of the fund, stale check, then the post-dated check, alteration, irregulation of a signature, frozen account, and the stop payment instructions, etc. So when the checks were issued as a negotiable instruments, there was always possibility of the same being issued without sufficient amount of a fund in the account. With a view to protect drawee, the check need was to felt that dishonor of the check he made punishable offense. So without purpose of section 138 to 142 were inserted by the Banking Public Financial Institution and Negotiable Instrument Clause, which is amended in 1988. This was done by the making drawer liable for punishment in case of bouncing the check due to some of the insufficiency of the funds on the account, with adequate safeguards to prevent the harassment on the uh, honest drawer. So what are the elements is given here under the section of 138 of Negotiable Instrument Act. That is, the first one is the check has to be drawn by the accused on the account which is maintained by him with a particular banker in a bank. Then the second one is given: the amount of money mentioned in the check is for discharging by the liability, either whole or partly. Then the check is dishonored, which means it is returned unpaid due to insufficient funds, or is returned because of amount of contained in the check exceed the arrangements made by the bank. So the offense is said to be committed at the exact moment of the check is returned unpaid to the holder or drawer of the check. So these are the elements given. So what are the expectations from these such provisions that are nothing contained in the section shall be applied until first one is the check has been presented to the respective bank within the period of its validity or within the 6 months of the time from the date on which the check was drawn from the bank, whichever is earlier. Then the payee in due course of the check has made a demand of the payment of the amount of money by providing notice or any writing to the person who has drawn the check, he should within 15 days of the receipt of information from the bank regarding the returning of the check which is unpaid. Then the third one is if the drawer fails to make the payment of the said amount of money to the respective payee or the person who is to receive the money within the 15 days of the receipt of the information of the notice received. So these are the three expectations given in the section. Then the section 138 of the Act deals with the dishonor of the check. It has no concern with dishonor of other negotiable instrument. Then the some of the ingredients of the offense are contemplated. So under the section 138 of the Act, so first one is the check must have been drawn for discharge of existing debt or liability that is legally recoverable, whatever the debts are there. So second one is a check must be presented within 3 months or within a validity of that period given in the act, whichever is the earlier. The check must be returned unpaid due to insufficient funds or it exceeds the amount whatever the arranged. Fact of the dishonor be informed to the drawer by notice within that the 30 days. Drawer of the check must be failed to make payment within 15 days of the receipt of the notice. So these are the ingredients given in respect of the dishonored of the check. So the next one is a jurisdiction. So considering the ingredients of the section 138 referred above honorable apex courts in the case of K. Bhaskaran and Shankaran. So in 1999 had given some jurisdiction initiative to the prosecution at any following places. So the given are the where check is drawn, the place is important. Then the where payment had to be made, then where check is presented for payment, which bank or which place is important. Then the where check is dishonored, and last one is where notice is served up to the uh, drawer. So the justification is also important. Then the notice must be in return informing that the check has been returned unpaid. Also, a demand of a check amount must be made and it should be the given in within 30 days from the receipt of the information of dishonor. So the 30 days is notice period is given in the act whenever the check is bounced. Then the cause of action arises when a notice is served on the drawer and drawer fails to make a payment of the amount of check within the 15 days. The limitation of file complaint is 1 month from the date of the cause of action. So however, the amendment of the 2002 court is empowered to take the cognizance of the offense even if the complaint is filed beyond the 1 month by is given after the amendment of 2002. The imprisonment that may imposed may extend to 2 years, while the fine may extend of twice the amount of check. However, the trial is conducted in summary way. Then magistrate can pass the sentence of the imprisonment not exceeding 1 year and amount of fine exceeding rupees 5,000. There is no limitation for awarding some of the compensation. So this is the procedure. Section 139 of Negotiable Instrument Act, then Section 140, Section 141, and Section 142. So let us discuss about the Consumer Protection Act, which is amended in 2019. So we want to understand what is here the introduction. The introduction is the Consumer Protection Act 2019 was enacted and passed by the Parliament on 9th August 2019, which was signed by the President. The Act become applicable from 20th July 2020. So the preamble of the Act is an act to provide for protection of the interest of consumers and for the said purpose to establish authorities for timely and effectively administration and settlement of a consumer's dispute and for matters connected therewith or accidental thereto. So what is the need or requirement of the new act? As we know, the earlier act is enacted in 1986, did not fulfill the requirements of digitization of the economy and the corresponding requirements of the law of for the goods and services in the digital form. So the facilitate consumerism in the digital manner, Consumer Protection Act 2019 was implemented. Consumer protection changes with growing consumerism and modification of covert impetus means buyer behavior. So the some of the digitization of economy and corresponding requirements of the goods and services and the act is amended in 2019. What are the rights of consumer? Consumerism promotes an adequate knowledge and safeguards various rights of consumers. So section 2 subsection 9 of Consumer Protection Act 2019 defines rights of consumer, which includes first one is the right of protection, second one is the right of information, third one is the right to access to variety, then right of heard, then right to seek redressal, and sixth is right to consumer awareness. So these are the important awareness rights given by the act under the section 2 to the consumers. So what is right of protection? In Article 21 of the Indian Constitution provides that no person shall be deprived on his life or personal liberty except according to the procedure of the establishment by the law. So the consumer has a right to be protected against the marketing of the goods and services which are hazardous to the life and the property. So the right is given by the Constitution to the consumer as a protection from the marketing of goods and services. So the right is important. Then second one is a right to information. It means the consumer has to right to know about the each and everything of the products and services. That is the what is the quality of the product, what kind of a quantity is there, then purity of the air, standard of the goods, then the price of the goods. These all the information must know to the customers. So nature and the manner of the performance of the services is also important in respect of the consumers. So the consumers need to be informed about the goods and services so that they can choose the better product and services for their serve. So the company also should take care about the given information of the products and services to the customers. Then next one is a right to access to variety. The consumer have right to select his required goods from the variety of the goods of services at a reasonable rates. So the consumer should get goods and services according to their needs. Thus, the seller should be sell their goods in variety and the services providers should supply the variety of the choices in their services. By this, consumer will be able to enjoy the variety of goods and services in the competitive prices available at the markets. So the right of access of the goods and services with the varieties, it is important right given under the Consumer Protection Act 2019. Then the right to hear. So the Consumer Protection Act 2019 in its preamble itself stated that to protect the interest of the consumers, to establish authorities for timely and effective administration and settle the consumers' disputes. So every consumer has a right to be represented so that consumer interest will be protected by the authority. In the chapter 4, explain that the details about the consumer disputes redressal commission, the act enable to establish three-tier system in the nation. At the first level is the district level, where the district commission is there. Then the second level at the state level, where the state commission is there. Then the third, there is a national commission working in the whole country. So the fifth one is a right to seek the redressal. Then the Consumer Protection Act 2019 provides for a speedy and fair justice to the customer whenever the dispute is there. So according to the section 39 subsection 1 of the Consumer Protection Act 2019, the Consumer Disputes Redressal Commission shall issue an order to the opposite party directing him to do one or more of the following, namely, that is to remove the defect in the goods, whatever the found, then to remove the deficiency in the services if they found, then the replacement of the goods, then return of the price if the product or services is not good or not satisfied the customer, then the pay compensation to the customer, and then last one is the discontinue the UTP or ITP, RTP. So these are the some redressal committee given the suggestions. Then last one is a right to consumer awareness. According to section 18 subsection 1 of the Consumer Protection Act 2019, it is one of the function of the central authority to spread and promote the awareness on the consumer rights. So the authority should educate consumers through newspapers, TVs, other medias. The authority can also create awareness through exhibition. So these are the important rights given under the section 2 subsection 9 of the Consumer Protection Act 2019. So these are important rights. So for the purpose of the examination, you should remember that the rights of the consumer is asking in the question paper as a short note to explain what are the rights of the consumers. So you should remember about the rights of consumers. Then silent features of the Act of Consumer Protection 2019 consist of a total 107 sections. So under the whole Act, there are 107 sections. This Act apply to all the goods and services provided by the different companies in the nation. So this act has provided various new provisions like harm, injury, product liability, supply, spurious goods, endorsement, design, etc. The chapter scheme of the act is as follows. The Consumer Protection Act contains 8 chapters. First one is section 1 to 2 deals with preliminary issues and the definitions of the act given. Then the second chapter is related to the consumer protection councils. Whatever the councils are available in the nation at the state level, district level, and the national level. Then the third chapter is related to section 2 to 27 deals with Central Consumer Protection Authority, which is formed by the central government. Then the chapter 4 is related to 28 to 73 sections deals with consumer dispute redressal commissions is there, which solve the problems of the customers. Then the Act provides three consumer dispute redressal commission to seek redressal at the district level, district commission for every district formed. Then the state commission is there at the state level. Then the National Commission of India formed at the national level at the Delhi. Then the chapter 5, section 74 to 81 related to the meditation. It consisted of establishment of the consumer meditation cell, duty of mediator, then the procedure of the meditation and settlement through the meditation. So the chapter 5 is one of the important in respect of the consumer, where the dispute is there and the dispute should be the solved under the meditation. Then the chapter number 6 is related to the product liability. The section 82 to 87 is there. This chapter consists the product liability action, liability of the product manufacturer, liability of the service provider, and liability of the product seller, and so on, is written in the section 82 to 87. Then the seventh chapter in 83 to 93, offenses and penalties given. Whatever the penalties or offenses, punishment is given in the here. In the respect of chapters 8, 94 to 107, miscellaneous is given under the act. हॅलो, माईक कुणाचा सुरू आहे? माईक तेवढा बंद करा. हॅलो, शुभांगी कांबळे. शुभांगी कांबळे. Hello. So the act is given the definition of the consumer. So consumer section 2 subsection 7 of Consumer Protection Act 2019 defines what is consumer, who is not consumer, clearly defined. So section 2 subsection 7, consumer means any person who buys any goods for a consideration which has been paid or promised or partly paid and partly promised or under any system of deferred payment, and includes any user of such goods other than the person who buys such goods for a consideration paid or promised or partly paid or partly promised or under any system of deferred payment, when such a use is made with the approval of such a person, but does not include a person who obtains such goods for resale or for any commercial purpose, that is consumer. So again, section 2 subsection 7, consumer means any person who hires or avails of any service for a consideration which has been paid or promised or partly paid or partly promised or under any system of deferred payment or and includes any beneficiary of such services other than person who hires or avails of the service for the consideration paid or promised or partly paid or partly promised or under any system of deferred payment when such services are availed of with the approval of the first mentioned person, but does not include a person who avails of such a services for any commercial purpose. So, the first definition given is related to the goods, and the second definition is given related to the services. So, again, the consumer dispute in the section 2 subsection 8, what is consumer dispute? Consumer dispute means a dispute where the person against whom a complaint has been made denies or dispute the allegations contained in the complaint. The explanation given, the consumer dispute must relates to defect in the goods or deficiency in the services which purchased to consume for the consideration. The complaint should be a buyer of a goods, hirer or availer of services, and the persons against whom complaint made must be seller or service provider who has denied the complaint. Then the Central Consumer Protection Authority, according to Section 2, subsection 4, Consumer Protection Act 2019, Central Consumer Protection Authority means the Central Consumer Protection Authority established under the Section 10 of the Act, in which Chapter 3rd of the Consumer Protection Act 2019 deals with the Central Consumer Protection Act Authority, in which the establishment of the authority. So the central government shall, by notification or the establishment of a central consumer protection authority to be known as the central authority to regulate the matters related to the violation of the rights of consumers, unfair trade practices, false or misleading the advertisements which are prejudicial to the interest of the public and consumer, and to promote, protect and enforce the rights of the consumers as a class of the society. So it is given in the section 10 subsection 1. Then the composition, the central authority shall consist a chief commissioner and other commissioners as may be prescribed to be appointed as a central government to exercise powers and functions under this the act. So the headquarter of this Central Consumer Protection Authority located at Delhi. The chief commissioner shall have the power and of the general superintendent's directions and control in respect of the all administrative matters of the central authority. So, what are the powers and functions of the central authority under the section 18 subsection 1 of the central authority? Shall protect and promote and enforce the rights of the consumers as a class and prevent violation of the consumer rights under this act. Again, the prevent unfair trade practices and ensure that no person engages himself in unfair practices. So, ensure that no false or misleading advertisement is made of any goods and services which is contravenes of the provisions of this act and the rules and regulations made thereunder. Again, the ensure that a person takes part of the publications of the any advertisement which is false and misleading. So number of the powers and functions given related to the central authority which is given under the act. Then next one is a penalties against false and misleading advertisement. According to section 21 of Consumer Protection Act 2019, where central authority is satisfied after the investigation that the advertisement is false or misleading and is prejudicial to the interest of any consumer or is एक 5 मिनिटं थांबा सर्वांनी.
हा ठीक आहे सर.
So, according to Section 2, subsection 4 of Consumer Protection Act 2019, Central Consumer Protection Authority given the chapter 3rd in respect to the some 4 contents. That is the last one is a penalties against the false and misleading advertisement. So, according to Section 21 of Consumer Protection Act 2019, where the central authority is satisfied after the investigation that the any advertisement is false or misleading and is prejudicial to the interest of any consumer or is an contravention of the consumer rights. It may by order or issue directions to the concerned trader or manufacturer or endorser or advertiser to publisher as the case may be or discontinue such a advertisement or to modify the same in such a manner and within such a time as may be specified in that order. So this kind of a penalty is given under the section of the 21 of Consumer Protection Act. Then Consumer Dispute Redressal Commission, Chapter 4th of Consumer Protection Act 2019 explains about the Consumer Dispute Redressal Commission, which is divided at national level, state level, and the district level. Where the district level, the district commission is there, and the state level, the state commission is there, and at the national level, the national commission is there. First, we discuss about the district commission. According to section 28 of the Consumer Protection Act 2019, the state government shall establish a district consumer redressal commission, that is district commission of each district of the state. So how the composition of the district commission? Each district commission shall consider a president and not less than two and not more than such a member number of member as may be prescribed, and in respect of consultation with the central government. So what is the jurisdiction of the district commission? So the district commission shall have a jurisdiction to the entertain complaints where the value of the goods and or the services paid as consideration does not exceed 1 crore rupees. सो या ठिकाणी काय ज्युरिस्टिकेशन कंझ्युमर डिस्ट्रिक्ट कंझ्युमरचं काय दिलेलं आहे डिस्ट्रिक्ट कमिशनचं की 1 कोटीपेक्षा जास्तचे जे डिस्प्यूट असतील ते या ठिकाणी काय केले जात नाहीत, सॉल्व्ह केले जात नाहीत. सो टेरिटोरियल ज्युरिस्टिक्शन काय आहे बघा. A complaint shall be instituted in a district commission within the local limit of the whose jurisdiction. So the opposite party or each of the opposite party ordinarily resides or carries on business or has a branch of office or a personally works for a gain, the cause of action wholly or in a partly arise or the complaint resides or personally works in for the gain. So the territorial jurisdiction is given. Then the procedure of admission complaint, section 38 subsection 1 of the district commission shall on admission of a complaint or in respect of cases referred for the mediation of on failure of the settlement by the mediation proceeds with such a complaint where the complaint relates to the any goods, the district commission shall apply received. Then the findings of the district commission. First one is section 39 where the district commission is satisfied that the goods complained against the suffer from any of the defects specified in the complaint or that any of the allegations contained in the complaint about the services or any unfair trade practices or claims for compensation under the product liability are proved. It shall issue an order to the opposite party for the directing him to do one or more for the following namely. So section 41 is related to the appeal. Any person by any order made, the district commission may prefer an appeal against the such a order to the state commission within the 45 days from the date of the order. Then the state commission, according to section 42 of this Consumer Protection Act 2019, the state government shall establish the state consumer dispute redressal commission in the state. So the composition of the state commission, each state commission consists a president and not less than 4 or not more than such a number of the members as may be prescribed in consultation with the central government. So what is the jurisdiction of the state commission? First one is a pecuniary jurisdiction and appellate jurisdiction is there. So appeal against the orders of district commission within the state is there. So the procedure of the state commission, the provisions related to complaints which is mentioned under the 38 findings under the 39 be applicable to the disposal of the complaints by the state commission. So the state commissioners can resolve the whatever the appeal appealed by the whatever the district commissions. So last one is the appeal according to section 51 subsection 1. Any person aggrieved by the order made in the state commission may refer or may prefer an appeal within 30 days to the national commission. So last one is the national commission according to 53 subsection 1 of Consumer Protection Act 2019. Central government shall establish a national consumer protection or dispute redressal commission to be known as a national then such a number of members as may be given in the prescribed format. Then the jurisdiction of the National Commission. National Commission shall have jurisdiction to entertain complaints where the value of goods and services paid as a consideration exceeds rupees 10 crores. So more than 10 crores disputes are there, they can apply as a directly to the National Commission. Then the complaints against the unfair contracts where the value of the goods and services paid as consideration exceeds rupees 10 crores. Then the appeals against the orders of any state commission is given also. Then the appeals against the orders of central authority. Then the procedure under the section 38 and finding under the section 39 shall be applicable to the disposal of the complaints by the commission which is given in the district commission also. Then the last, according to the section 67, any person aggrieved by the by any order made by National Commission is in exercise of the powers under the section 58, that is original jurisdiction only, may prefer an appeal against the such order to the Supreme Court. So then e-filing of complaints according to section 17 of Consumer Protection Act 2019, a complaints relating to violation of consumer protection rights or unfair trade practices or false or misleading advertisement which are the prejudicial to the interest of consumers as a class may be forwarded either in written or in electronic mode to any one of the authorities, namely district collector or commissioner of regional office of the central authority. In section 35 subsection 2 of the act, manner in which complaint shall be made explained as every complaint filed in district commission oblique state commission oblique national commission shall be accompanied with such a fee and payable in such a manner, including electronic form as may be prescribed given in the website. So the electronic filing of the complaints in a commissions shall be effective from the date of such a category of cases as may be notified by the president of the National Commission from time to time. So the product liability is there. Product liability means the responsibility of a product manufacturer and product seller of any products and services to compensate for any harm caused to a consumer by such a defective product manufactured or sold or by deficiency in services relating to there too. So the given in the section 2 subsection 34. So the example is given also here. Delay in crediting the proceeds of the check after collection of the consumer's account is deficiency in the services from the bank. So here the product liability or service liability is there from the bank point of view. So the product liability chapter 6 deals with the product liability. Section 82 of Consumer Protection Act stated that about the application of compensation under the product liability. So complaint shall apply to every claim for compensation under the product liability for any harm caused by the defective product manufacturing by a product services provider or sold by the any seller from the market. So the panel consequences is there given under the Consumer Protection Act in section 2 subsection 35, that is the product liability action means a complaints filed by a person before district commission or state commission or national commission as a case may be for claiming compensation for the harm caused to him. Thus the forum will be award compensation to the complainants according to the their claim, but there are some of the certain punishments to the companies. So penalties for misleading advertisement, section 228 of Consumer Protection Act 2019 defines misleading advertisement in relation to any product or services, means advertisements which false describes such product or services, gives a false guarantee to, or is likely to mislead the consumer as to the nature, its a substance, and then their quantity or quality of a such a product or services. Again, the conveys an express or implied representation which, if made by the manufacturer or seller or service provider thereof, would constitute an unfair trade practices. So the penalty is there. Then deliberately conceals important information given to the authorities. Then the punishment for false or misleading advertisement. Section 89 of Consumer Protection Act states that any manufacturer or service provider who cause a false or misleading advertisement to be made, which is prejudicial to the interest of consumer, shall be punished with imprisonment for the term which may extend to the 2 years or with fine which may be exceed to the 10 lakh rupees, and for every subsequent offense be punished with the imprisonment for a term which may be extend to 5 years, and with fine which may extend to the 50 lakh rupees. So the example is given here. When a shampoo companies influence consumer that their products prevent their fall and dandruff by just one wash, a soft drinks company show that this examples shows that the that will not um, uh, possible from the one-time use. Then the alternative dispute resolution is a process and technique that settle the disputes. Counsel, mediation, negotiation, arbitration is the process of the ADR system. It is also allows to the parties to come up with the more creative solutions and settle their matters outside the court. So it is given also in the chapter number 4. Then the chapter number 5th given related to the meditation. According to the section 74 of the act, it states that the government shall establish consumer meditation cell to each of the district commission and the state commission of the state. So the central government shall establish the consumer mediation cell at the national level also. Every mediation cell set up in a commission shall have a panel mediators according to consumer protection uh, mediation rules 2020. So the last one is the unfair trade practices is there. So section 2 subsection 47 unfair trade practices means a trade practices which for the purpose of promoting the sale, use or supply of any goods or for the provision of any services adopts any unfair method or unfair or defective practices, including any of the following practices, namely, here is a consumer dispute or redressal agency is discussed where as the definition of consumer dispute is mentioned in the section subunit 4, the consumer redressal agency subunit 6 deals with the disputes redressal mechanism. Three-tier system is there in the country, that is district commission is there, state commission is there, and the national commission is there. So the review we will take here some of the every commission shall have the power to review the any of the order passed by it if there is an error apparent on the face of the record, either its own motion or on an applications made by any of the parties within 30 days such order. Then the tenure of the commission, the president and every member of the district and state commission shall hold office for a term of 4 years or up to the age of the 65 years, whichever is the earlier. Then the president and every member of the national commission shall hold office for a term of 5 years or in case of a president up to 70 years of age. In case of a other member 67 years of age, which is whichever is earlier, which given in the tenure of the commission under the section of the 55 of Consumer Protection Act 2019. And the proceeding is there. On the receipt of complaint, the commission may by order admit or reject the complaint. If there is a possibility of settlement, then the complaint may be referred to the mediation under section 37, that the procedure has been applied by the commission under the Consumer Protection Act. Then the qualification of presidents and member of the district commission, a person is or has been or is qualified to be district judge is a person. So basically what is happened here at the district level, president is a district judge. A person shall not be qualified for appointment as a member unless is of not less than 35 years of age, possesses of a bachelor degree from the recognized university, then a person uh, of ability, integrity and standing and having special knowledge and professional experience of the not less than the 15 years of the consumer affairs, law, public and affairs, then the administration, economics, commerce, industry, management, finance, engineering, technology, public health, or the medicine. So some of the sectors are given here where the members are selected from that. So third one is at least one member or president shall be woman. So there is a reservation is given to the woman for the panel. In the qualification of the president and member of the state commission, a person is or has been as a judge of a high court. So who are the judge of high court is a working as a president of the state commission of the consumer redressal commission. Then a person shall not be qualified for appointment as a member unless he is of not less than 40 years age of. So also he have some 10 years experience again the officer of a district court or tribunal areas. So 50% member of the this from the category. Then the person having bachelor degree from recognized university is similar for the district and state commission, having experience more than 20 years in respect of district commission. There is a 15 years experience here exceeding the 5 years. So the state commission members are from consumer affairs, law, public affairs, administrative and economics, commerce, public health and medicines. These are the sectors. Then the one of the whom shall be a woman also is required for the panel. Thank you, students, for this. Today we are completing here the first part of the second unit, that is Negotiable Instrument Act 1881, and the second part of the unit, that is Consumer Protection Act, which is amended from the 1986 to 2019. So in respect of the your examination, the both the Negotiable Instrument Act and the Consumer Protection Act 2019 is important. So make a proper study to understand the definitions, the concepts, how it is related to. It is very important to for your examinations. काही शंका असतील तर विचारू शकता 5-10 मिनिटं. ठीक आहे, थांबूया आज.